Thank you for joining us today. I'm Dan Sutherland, Head of the Professional Services team at Fox Williams. I'm joined here today by two experts in advising law firms, Aron and Grace Waterhouse from our employment team. So many of you watching this webinar today will be familiar with the 2019 SRA Code of Conduct and all the changes that that Code of Conduct brought when it was introduced. That Code of Conduct hasn't stood still, and recently the SRA has introduced a new rule imposing an obligation on lawyers and their firms to treat colleagues fairly, and also for partners to challenge behaviour that fails to meet that standard. We think that's an important change, and we expect that in practice this will become a rule that many firms will have to grapple with. So why has the SRA made this change? Well, I think as well as general changes in attitudes to how people should be treated at work, there have been some particular concerns around law firms. In 2019, there was a junior lawyers survey in which 75% of the respondents found that firms weren't doing enough to support them in dealing with stress at work. Lawcare has also found that 20% of lawyers have been subjected to bullying or discrimination at work as well. Following all that sort of news, the SRA in 2022 conducted its own review, which they called the Workplace Culture Thematic Review. What that found was that around a quarter of people responding felt that their firm didn't have a positive culture, and concerns were raised about long hours, high pressure environments and bullying. So I think on top of that, there's also been a number of quite highly publicised and often quite salacious cases involving solicitors, which has really portrayed the profession in quite a poor light. I think worse still, from the SRA's perspective, some junior lawyers have been caught up in cases of misconduct because they haven't felt an ability to speak up. And I think the fair treatment rule that's come into force is trying to address these concerns based on the SRA's perspective that a toxic environment and unfair treatment, it can both damage the legal profession and, in their view, harm the ability of firms to properly service their clients. So, Aron, like most SRA rules, this is quite a brief rule, but it needs close reading. Can you talk us through it?
Yeah, sure, Dan. So the rule is broken down into two parts. There's a part for lawyers and there's a part for firms. And the part for lawyers is also broken down into two parts. So first of all, the first rule is that lawyers must treat each other or treat their colleagues fairly and with respect, and they must not bully, harass or discriminate against each other. And then secondly, managers are under a positive obligation to challenge behaviour that doesn't meet Rule 1. The rule for firms is that firms must act in accordance with the rules, and the SRA, as you said, is keen to make sure that firms have the right culture and that people are encouraged to speak up if they see bad behaviour. When I say colleagues, that rule is actually drafted quite widely. So it doesn't just mean other lawyers within the firm, it also means barristers or experts that are instructed by the firm. And it doesn't mean, I think critically, it doesn't mean the way that you interact with your clients, or it doesn't mean the way that you deal with opposing counsel. If a lawyer believes there's been a material breach of the rule, then they're under an obligation to speak up and to report that to the SRA. So people do need to be very familiar with this and to make sure that they are alive to issues and that they're properly educated. And I think, interestingly, it will mean that matters that previously were dealt with in-house, such as allegations of bullying, are now a matter which the SRA will be interested in.
So clearly the Code of Conduct does only really technically apply to solicitors and regulated law firms. But are they the only people in a firm who are likely to need to be mindful to this rule?
Well, I think actually everyone that works in a law firm needs to know, and they need to know for slightly different reasons. So first of all, the partners in a law firm and the COLP need to be intimately familiar because they're responsible for the way that a firm is managed. So they need to understand both the way that the rule impacts on themselves as individuals and on the way that it affects the firm. Then I think secondly, the COLP and the HR team need to understand the rules carefully because first of all, they need to consider whether people need training or whether their policies and procedures need updating. And then they also need to understand how to deal with issues if they're brought to their attention. So if someone challenges behaviour or if they're concerned that there's a pattern of behaviour by someone and they're not they're not learning from the challenges, then they need to think about how to document that, what action to take against the partner, for example, training or disciplinary action, and they need to understand the reporting obligations. Then associates are caught by the rule because they're under an obligation not to treat people unfairly or disrespectfully, or to bully, harass or discriminate, of course. And so they need to be familiar with the rules. And then finally, anyone that works within a registered firm and isn't qualified should also understand the rule so that they're aware of what kind of behaviour wouldn't be appropriate.
Thank you. So Grace, I think one of the biggest questions that law firms will have is what does fairness mean? Because it's quite a subjective term. There is some guidance, but can you give us some context?
Yeah, so the unfair treatment rule basically has two sides of it. It has the positive obligation to treat our colleagues fairly, and then it has the prohibition on not to bully, discriminate or harass. Now, the prohibition is slightly more easy to understand because discrimination and harassment, for example, are legal terms. They're defined in the Equality Act. Bullying, slightly trickier because it's not a legal term. It's not got any legal definition. But there is some guidance from the SRA on that, and they've adopted the same definition as ACAS. So that's behaviour that's offensive, intimidating, malicious or insulting, or behaviour that indicates some abuse of power, humiliating someone, for example. The positive obligation to treat others fairly is slightly more nebulous because really that could mean a whole range of things. What we do know from the SRA is that this is about serious unfair treatment. There is a materiality threshold to it. The SRA are not turning into the employment police. So we know that it needs to be serious. We also know that some factors will aggravate treatment. So things like if it's intentional, if it's blatant or repeated, when challenged, if it's not corrected, if there's a real abuse of power, if there's a power dynamic, or if it's in front of clients or perhaps in front of junior colleagues. We've also got a few case studies from the SRA, which give us some indication of what they consider to fall one or the other side of the line. So, for example, a paralegal who complains about bullying and unfair criticism, there hasn't been a pattern of concerns in the firm, it's investigated properly, that doesn't fall foul of the rule. But an NQ solicitor who lacks a lot of experience, who has an overwhelming number of cases, who's ridiculed when they ask for help, that does fall foul of the rule. And I think you can see how the SRA might be treating those two things differently because one has a much wider implication for the public, for example. I think in practice, some cases it will be immediately obvious that this rule is engaged. In others, it's going to be a lot more grey, and firms might want to take advice on it. But I think one of the most crucial things is that firms do need to investigate, because if they haven't investigated properly, then they really won't know which side of the line it's likely to fall. And also the SRA just do expect firms to investigate.
Thank you, Grace. So, in our experience, the SRA has often a certain perspective on how it expects rules to arise in practice, and the guidance will tend to reflect that. Aron, this rule's been in place since April. Where, in fact, have we been seeing this rule arising?
Well, interestingly, we've seen it a lot in employment disputes. So we have encountered a number of situations where both partners and employees have used the rule to give themselves employment protection that perhaps otherwise they wouldn't have had before April 2023. So, for example, a partner might complain about the behaviour of a colleague and make it very clear that they're blowing the whistle. And so that gives themselves whistleblowing protection. And if they suffer any detrimental treatment, which could be, for example, a reduction in profit share or maybe not moving them up the lockstep, then they might say that that's because they've blown the whistle. Similarly, lawyers are using this and complaining about the behaviour of a partner and saying they've been treated unfairly or even bullied, and again they're saying it's whistleblowing. And so if their performance is criticised or they're taken through a disciplinary process, then they might say that's retaliation for having complained about a breach of a rule, and that's contrary to our whistleblowing legislation. We are also seeing occasionally people trying to set up constructive dismissal claims. So if they accuse the firm or a partner of fundamental breach of contract, that gives them an entitlement to walk away immediately and bring an unfair dismissal claim. That only applies to employees. Finally, I think the situation we've seen a few times, fortunately not very many times, is where people have used this rule as part of leverage in negotiations. So perhaps if a firm has asked a partner to leave, the partner might turn around and say, well, actually, I'm aware that one of my colleagues has been bullying someone, and if you don't pay me more money on my exit, then I'm going to report you to the SRA. And to me, it seems that that's bad faith, and that's completely contrary to the SRA's guidance about the circumstances in which this should be used. And also, it's overlooking that partner's own responsibility to have brought a material breach of the rules to the SRA's attention. So I think that would backfire in any negotiation and potentially could expose that partner to SRA regulation, an SRA inquiry themselves.
I think partners are going to be a big feature of this rule in practice. In particular, they have that additional obligation imposed on them as they are managers in SRA speak. They have an obligation to challenge behaviour that fails to meet the standard. So Aron, why was that sort of obligation imposed, and how is that going to work in practice?
Yeah, I think that this is the real major development from my perspective. The way that partners do go about speaking to each other to ensure that their firms have the right culture and people do feel able to speak up, and that the kind of the partner that has serial behavioural issues is actually dealt with and not just allowed to continue treating people unfairly or bullying them simply because they're a rainmaker. What I think is going to be particularly interesting is the way that partners challenge behaviour and then make a note of the way that they've challenged that behaviour. And none of this is specifically addressed by the SRA. In terms of the way that issues are challenged, I think it really depends on the situation. So there'll be circumstances where it would be appropriate to speak up in a meeting. The SRA expects immediate intervention, and it might be that if you're witnessing a colleague bullying someone, then you do need to step in immediately. On the other hand, there might be circumstances where an inappropriate comment's made and you feel it's much better to wait until the meeting or the phone call is finished and then to have a quiet word with the partner and point out that perhaps their behaviour fell below the standards that are now expected by the SRA. There will, of course, be circumstances where it's important to take more formal action, so to report directly to HR or to the COLP about someone's behaviour so that formal training can be given. If the partnership agreement allows it, disciplinary action against a partner, certainly disciplinary action against an employee, and training so that the individual understands their obligations. And in an absolute worst case scenario, with the most egregious behaviour, it might be appropriate to dismiss an employee or to expel a partner. In terms of record keeping, I think that's a really tricky one. Again, it's not specifically addressed by the SRA. I think if you have a quiet word with someone, it's probably sensible to keep an internal note of that, so that if there is a repeat incident or if you're challenged for not having reported something or dealt with it yourself, then you can show that you have. In other circumstances, perhaps an email to someone just following up on a conversation, trying to treat it as a development point and to help them, to make it clear that you are not chastising them, you're trying to improve their behaviour. And obviously on occasions, mentioning it in appraisals or even as part of a disciplinary issue. I think what people absolutely must keep in mind is that any notes that are kept, any emails to people, WhatsApps, notes on appraisals, they'll all be disclosable as part of any employment tribunal litigation. If someone submits a DSAR asking for their personal data, or if the SRA decides to investigate. So people do need to be really careful about what they say and how they say it.
So Grace, Aron's talked a bit about the record keeping aspect. What other kind of practical steps are we seeing firms take to try and address this rule?
Yeah, so awareness is really key because, as Aron said, this is a rule that impacts everyone from the most junior to partners. For associates, they're going to need to understand that the rule exists and what it means. For partners and managers, they obviously have this additional obligation to challenge, and so it's going to be important that they're given training on that. Now, at a bare minimum, the firm can circulate a note and we have an FAQ document that can help with that. I think best practice is to give them some training on it, in-person training that allows them to understand the mechanics of challenging, what the firm expects, real-life examples and scenarios. And again, that's something we're more than happy to help with if that would assist firms. I think firms also need to think about their policies, because certain policies will interact quite closely with this rule. Policies like bullying and harassment, equality and diversity, the whistleblowing policy as well. And we want to make sure that the policies don't interfere with the rule. Instead, they allow firms the flexibility to deal with matters appropriately. There'll also be some policies that interact with the kinds of issues that arise under the rule. So in particular, we see issues like alcohol, external events, performance management. All of these types of issues can really generate behaviour that might be caught under the rule. So it's important that people understand their obligations under that as well.
Oh, thank you, Grace. And thank you, Aron. So yeah, hopefully that was a helpful canter through the implications of the new rule. We think with the best will in the world, this is something that's going to be coming up for a lot of law firms and our clients, unfortunately. Of course, it also brings into focus the 2019 rules on breach reporting. And we at Fox Williams, of course, stand ready to help you with both this rule, the underlying dispute, and should the worst come to the worst, how to interact with the SRA. So thank you for joining us. We hope you found this a helpful webinar and that you can join us again for another Professional Services Group update.